And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The court. That just changed everything. If you own a firearm, if you carry concealed, or if you still believe the Bill of Rights matters, what just came down from the Supreme Court is going to affect your life. A 6-3 ruling has completely rewritten the rules on gun regulation in America and fundamentally altered how your state can treat Second Amendment freedoms. From permit systems to training mandates, from waiting periods to constitutional carry laws, everything just got turned upside down. This isn't about partisan politics. This is binding legal precedent that reaches into every corner of the country and touches every gun owner's daily reality. We're breaking down the 10 critical changes you need to understand right now, because ignorance of these shifts could put you at risk when you can least afford it. Chapter 1. The ruling that shook the foundation. The Supreme Court just delivered a 6-3 decision that's reverberating through the entire legal system. At its core, the question was simple but powerful. Can state governments force ordinary citizens to justify their need for protection and jump through endless bureaucratic hoops before exercising a constitutional guarantee? The answer from the highest court was absolutely not. This decision doubled down on the landmark 2022 Bruin ruling, which established that every gun law must be rooted in America's historical traditions. What it confirmed is that constitutional carry represents the default position for law-abiding Americans. Any statute requiring citizens to prove special justification is now legally vulnerable. Once again, the court placed historical analysis at the center of constitutional review. Government red tape and approval systems can no longer serve as roadblocks to fundamental liberties. Through this ruling, the Supreme Court sent a message to every legislature. The Second Amendment carries the same weight as freedom of speech and protection from unreasonable searches. It's not something granted by the state. It's a right that predates government itself. Chapter 2. The end of subjective permit systems. Before the Bruin decision, states like California, New York, and New Jersey ran what they called may-issue permit schemes. Even when someone passed every background check and completed all the required training, a local bureaucrat could still reject their application based on nothing more than personal discretion. Those days are numbered. This new ruling strips away the arbitrary power that let officials decide who gets rights and who doesn't. New York's good cause standard has been gutted. California's system, where county sheriffs hold veto power, is facing serious legal problems. Restrictive regimes in Hawaii and Maryland are under attack in the courts. The new standard requires judges to examine historical precedent, not contemporary political opinions. States clinging to discretionary approval systems are watching the clock run out. They'll either have to reform their statutes or watch federal judges dismantle them piece by piece. What this means for citizens is straightforward. Your constitutional rights can't depend on what county you live in or whether the local sheriff likes you. Chapter 3. Time can no longer be a weapon. For years, states hostile to gun rights weaponized administrative delays, letting permit applications sit in limbo for half a year or more to discourage people from even trying. That tactic just ran into a constitutional wall. The court has ruled that the right to bear arms is immediate and present, not something that can be indefinitely suspended through procedural foot-dragging. Federal judges are now treating unreasonable processing delays as outright constitutional violations. Jurisdictions that let applications languish for 6, 8, or 12 months are facing injunctions. Legal challenges have already hit the courts in Illinois, Massachusetts, and elsewhere. Judges are issuing orders demanding states process applications within reasonable timeframes. The timeline itself has become a constitutional battleground. Every week that a qualified citizen sits in bureaucratic purgatory is now seen as a week their rights have been stolen, and the courts are making it clear that won't be tolerated anymore. Chapter 4. Training requirements. Face legal reckoning. Nobody disputes that firearms training serves an important safety function, but for too long, state governments have weaponized training requirements by making them prohibitively expensive, time-consuming, and difficult to complete. The Supreme Court just put those tactics under the microscope and found them constitutionally suspect. These modern training requirements are being measured against what existed in early American history. Laws that have no parallel in the 18th or 19th centuries are getting struck down. Places like Maryland, Connecticut, and California are now in the legal crosshairs. High costs, mandatory range time, and classes stretching over multiple weeks are all being challenged. To be clear, this doesn't diminish the value of proper instruction. What it does is prevent governments from turning education into a barrier designed to keep people from exercising their rights. Being a responsible gun owner is a personal commitment, not a government checkpoint you have to pay to pass. Chapter 5. Background checks need limits too. The court didn't eliminate background checks, but it did impose constitutional guardrails on how they can be implemented. The new standard is clear. Verification systems must be quick, accurate, and can't be used punitively. Processing delays caused by system glitches or applications stuck in indefinite limbo are now potentially unconstitutional. NICS checks that extend beyond the standard 3-day window are being scrutinized. States running redundant or layered screening systems are facing lawsuits. Holds placed on purchases based on vague suspicions may violate the Constitution. Extended waiting periods in California, Washington, and similar states are under fresh legal review. The Supreme Court's position is straightforward. Either the system identifies a disqualifying factor quickly, or it needs to get out of the way. When justice moves slowly, rights get trampled. Chapter 6. The Training Mandate. House of Cards. State legislatures have spent decades using mandatory training laws as a filter to control who gets to exercise their carry rights. This Supreme Court decision just kicked the legs out from under that entire structure. What the court made unmistakably clear is that even requirements dressed up as public safety measures can't stand if they place undue burdens on constitutional freedoms. Consider Maryland and New York, where applicants currently face up to 16 hours of mandatory classroom time plus live fire qualifications. Those requirements are now legally questionable. California's complex multi-phase system with repeated classes, certification renewals, and mandatory in-person appointments could be on the chopping block. Legal analysts are already debating whether training should shift from mandatory to strongly recommended. The new constitutional test asks whether any prerequisite has clear roots in early American practice. This ruling doesn't say training has no value. It says governments can't use training as a weapon to deny access. Your ability to defend yourself can't hinge on whether you can afford a 4-figure course or take 3 weeks off work. The bottom line is simple. The Constitution isn't something you earn through a certificate program. Chapter 7. Rethinking the background check system. This decision has thrown the entire background check debate back into the spotlight. While the court didn't abolish these systems, it fundamentally redefined the constitutional boundaries they must operate within. The central question now is whether modern verification systems, which are often sluggish, redundant, or shaped by political agendas, have any real basis in historical constitutional practice. Several justices observed that America's founders never envisioned requiring citizens to obtain government clearance before exercising fundamental liberties. Waiting periods that push lawful purchases weeks or months into the future are increasingly seen as unconstitutional impediments. States operating multiple overlapping verification systems may find themselves sued for creating unnecessary obstacles. Even federal waiting period rules could face judicial review if courts conclude they delay legitimate access without producing measurable safety benefits. What we're witnessing is the start of a broader legal push. Second Amendment lawyers are already building cases that argue these systems, despite good intentions, have morphed into tools of obstruction rather than genuine public protection. The court just gave them the legal ammunition to make that argument stick. Chapter 8. Who really controls gun rights? One of the most significant constitutional questions this case raised is about ultimate authority. When state statutes conflict with the Second Amendment, who gets the last word? The majority made their position crystal clear. Constitutional protections are nationwide standards. State lines don't diminish them. States that keep enforcing restrictive firearms statutes are facing swift federal court intervention. Federal judges are now fast-tracking challenges to state laws that contradict this new precedent. Even federal agencies like the ATF are being evaluated through the same historical framework that the Bruen decision established. Any government body, whether at the state or federal level, that tries to whittle down Second Amendment protections will face heightened judicial scrutiny going forward. This represents more than just a shift in the balance of power. It's a fundamental recalibration of constitutional authority. For decades, jurisdictions like California, New York, and New Jersey pushed the envelope on how far they could regulate firearms. Now those same states are discovering that the federal court system is standing as a constitutional roadblock they can't get around. Chapter 9. Bruen gets supercharged. The 2022 Bruen case was already a watershed moment, but this new ruling elevates it from important precedent to controlling doctrine. Moving forward, every Second Amendment legal challenge will be built on the Bruen framework. The test is now unavoidable. Does the regulation in question align with historical American traditions around gun ownership? This ruling amplifies Bruen by making historical analysis not just preferred, but absolutely required. States can no longer justify restrictions by pointing to modern crime statistics, contemporary fears, or current political priorities. Courts are now mandated to examine the original meaning and historical context of the Second Amendment. What results is a dramatically higher legal threshold that's going to sweep away huge numbers of modern restrictions across the country. This decision has ushered in a completely new phase of constitutional interpretation. Bruen isn't merely a legal standard anymore. It's become the fundamental framework through which all gun rights cases will be judged. Any regulation that can't point to clear historical roots is going to have a very difficult time surviving judicial review. The scales have permanently tipped in favor of individual citizens. Chapter 10. Where do we go from here? The effects of this ruling won't be contained to courtrooms and judicial opinions. The ripples are already spreading through state legislatures, federal agencies, and advocacy organizations nationwide. The debate has fundamentally shifted from whether gun rights exist to how expansively they'll be recognized. Legal challenges citing this decision are already being filed in over a dozen states. States with strong Second Amendment support are rapidly moving to expand permitless carry and strengthen preemption statutes. Meanwhile, gun control states are scrambling to develop new regulatory approaches that might survive this tougher constitutional standard. The ATF's regulatory actions, particularly around firearm classifications and enforcement priorities, will now face intense scrutiny under this strengthened framework. Make no mistake, this ruling isn't the finale. It's the opening salvo in a sustained legal campaign to restore the Second Amendment to its original constitutional meaning. The Supreme Court has established the boundaries. The coming battles will test who has the determination to hold that line. A new chapter begins. The Supreme Court has delivered its verdict. Constitutional rights don't require government permission, and the state no longer enjoys the presumption of authority. The burden of proof now falls squarely on those who would restrict freedoms. For decades, responsible gun owners have played defense, reacting to wave after wave of new regulations and restrictions. That defensive posture just changed. If you value accurate legal analysis, verified updates on evolving firearms law, and a clearer understanding of the regulations shaping your constitutional freedoms, make sure you're staying connected and informed. The legal landscape is shifting rapidly. New precedents are being established, and for the first time in a generation, constitutional momentum favors the rights of citizens. Stay informed, stay within the law, and above all, stay free.